Good evening, everybody. My name is Alina Sheltsova. I am an immigration attorney from Brooklyn, New York. Today we have our Wednesday's Legally Speaking seminar on VAwa, or Violence Against Women Act. Violence Against Women Act was first adopted, I believe, in 1994. Some people ask me, only women can benefit from it? No, it's not only women who can benefit from it, even though the name of it is covering only women. Men may benefit from it as well. In fact, Violence Against Women Act covers spouses and children of U.S. citizens and permanent residents and parents of U.S. citizens. So the law does not discriminate based on gender with this respect. What is Violence Against Women Act? Well, it's a law that helps certain immigrants to self-petition themselves to stay in the United States and receive the green card. As many of you probably aware that one of the ways to stay in the United States is to marry a U.S. citizen or permanent resident and adjust status to one of a permanent resident based on marriage and based on relationship with the U.S. citizen or permanent resident. But what if, we're going to talk more about the marriage, but the qualifying relationship also covers parent and child relationship and parent and adult U.S. citizen child. So it can be child who needs protection, and it can be a parent or an adult of an adult who's a parent of a U.S. citizen who needs protection and is covered by the act. So basically, for somebody to stay in the United States, a person has to have this qualifying relationship. And sometimes what to do if that U.S. citizen or permanent resident does not want to apply, or makes it very difficult for the non-citizen. And what if in addition to that, there is an abuse going on? Very often, a U.S. citizen, unfortunately, very often that it happens, the U.S. citizen spouse, be it a man or a woman, holds over his or her power for to apply for the non-citizen over that non-citizen's head and uses it to control the person. Or sometimes just not even being discussed, the immigration benefit itself, but the relationship is abusive, and the non-citizen gets stuck in this relationship because he or her is afraid to leave, is afraid that he or she will be deported, and does not know what to do. Because under the common knowledge, the citizens or permanent residents' help is needed to obtain the legal benefits in the United States. Well, that is why the law was created. The law was created to help people in difficult situations and allow them an opportunity to petition for themselves without the need of that person who is an abuser. So number one, there should be a qualifying relationship. If it's a marriage, the person has to be legally married or has to believe, if it's a bigamous marriage, meaning that, let's say, a U.S. citizen married the battered spouse without having a legal ability to marry. He was already married to somebody else. So in the eyes of the law, the marriage was not valid. But if the non-citizen believed that the bigamous marriage was valid and treated this as a valid marriage, non-citizen can nevertheless proceed with a self-petition. So there have to be marriage, and somebody who's just residing with a U.S. citizen, unfortunately, in most situations, will not be able to use the VAwa Act unless it's a child or a parent. The marriage in the marriage, during the marriage, the non-citizen has to be subjected to extreme cruelty or battery. What is it? Well, it's an abuse. Abuse can take different forms. It does not have to be physical beating, even though it's as horrible as it sounds. The physical act of violence is one of the strongest evidence of the abuse, but it doesn't have to be physical violence. It can be psychological abuse as well. And there is case law saying that that does not have to be abuse, does not have to be only in physical form. So there should be this abuse. The marriage should be a real marriage. When somebody enters into a fraudulent marriage, let's say a non-citizen says, well, you know, I'm going to pay you to get my green card, and then later that payee, the person who receives the money, subjected the person who paid him to an abuse, that's not going to help the non-citizen to get the green card. The marriage has to be a real marriage. The application, what to do if the people get divorced? Can a non-citizen still apply? Yes, he or she can, as long as she or he does it within 2 years of divorce. Now, the law distinguishes different consequences of application at different stages of the relationship. Let's say somebody who's still married is applying for VAwa self-petition. Can they do it? Yes, they can. Is the abuser, or does the abuser have to know about the petition? No, the abuser does not have to know about the petition. In fact, very often it happens that the non-citizen is applying for submitting application for self-petition, and he or she, this non-citizen, does not have proof of status of the abuser. Well, they're not really required. It's good if you have a copy of the U.S. citizen passport or green card, but if you don't, the USCIS will check it for you. So it means that USCIS does not require you to go to your U.S. citizen spouse or permanent resident spouse and say, hey, by the way, I'm filing self-petition. Could you give me proof of your status, because otherwise I will not be able to get my documents. No, you don't have to do it. USCIS will do it for you. If the relationship results in a divorce, in most of the cases, the self-petitioner has to demonstrate that the divorce was based on extreme cruelty or battery. Self-petitioner will not have to demonstrate it if the divorce occurred after the filing for submission of the VAwa petition. Can the self-petitioner remarry? Yes, but only after the VAwa petition is approved. If, for example, I was married to U.S. citizen number 1, and he was subjecting me to extreme cruelty, battery, was beating me up, did not treat me nice, I left him and I filed for my petition, self-petition. And then within a short period of time, I met this wonderful guy and decided to marry that person. What's going to happen to my self-petition? Well, the self-petition will be denied. But if the petition was first approved and then I marry somebody, then the petition remains valid. So there are many different technical situations in this process. Even though the process is very forgiving, and let's say if I entered the country illegally to begin with, and then I met this person who was my abuser, I still will be able to receive my green card if my self-petition is granted. In most cases, in most cases of adjustment of status under other categories, I will not be able to receive my green card if I enter the country illegally. So that's the process helps people with this respect. What if somebody is overseas? Very often I receive inquiries saying that, well, I used to reside with my U.S. citizen spouse in the United States, but he never or she never applied for me, and now I'm overseas. Can I still use the VAwa? Well, in many situations, yes, you can. If you can show that the abuse happened, some of the abuse happened in the U.S. But what if in addition to this, I have another problem? I got out of status while I was in the United States. Well, we all know that if somebody was out of status or accumulated unlawful presence in the United States and then left the country, they will not be able to come back for 3 or 10 years because there is a bar. What to do in this situation? Well, the law says that even in this situation, the person will still be able to come back to the United States in most of the cases if he or she can show that unlawful presence was connected to the abuse. That's very important because otherwise the person would need a waiver, and probably the waiver will be very hard to get because the waiver is usually based on the relationship and showing of extreme hardship to a U.S. citizen. And if you don't have this good relationship with a U.S. citizen to show that you'll be instrumental to his or her life, and at the same time your self-petitioner it's going to be impossible showing. So the law helps with this respect as well. The law, VAwa law, also helps those who entered the country on different types of, or have different types of bars that would preclude them to apply for permanent residency otherwise. Let's say somebody has a K1 situation, and each K1 case is different. Sometimes a person, K1 is a fiancé visa, came to the United States and married the petitioner within 90 days, but did not file for his or her documents, and later is seeking to get permanent residency. Sometimes the K1 fiancé never married the petitioner who invited her, and it makes a big difference in this situation. So I would not focus my presentation right now on K1 cases because they're very complicated. So how does a case start for VAwa self-petitioner? Well, there is a form called I-360 downloadable from USCIS website, and there are instructions to the form, and the person has to present evidence of the abuse when they submit this form. What those evidence may include? Well, first of all, and the strongest evidence one may present are copies of orders of protection. If there is an abuse going on, if you feel uncomfortable in your house, and as I said, it doesn't have to be physical abuse, the person can and should nevertheless ask for an order of protection, and those orders can be granted in criminal court if there is a criminal case, criminal charges, or it can be granted in family court, by family court. Orders of protection. Sometimes women are afraid to go to court and they rather would call a shelter. So the records of calling a shelter and the records of processing by shelter and using a shelter are admissible as well. It can be photos showing the physical harm, bruises, different things that the abuser is forcing you to do. It can be affidavits by friends and family, people who witness the suffering, and they can say, yes, this person deprived so-and-so of income or took her money and did not allow her to spend her money and just forced her to put the money into his account only. The person, very often what happens in cases of abuse, the abuser files for initial papers for the conditional green card and then refuses to go for an interview or refuses to file for the petition to remove the condition. So each situation is different. Evidence of each case will be different. There is a lot of materials online about the evidence, but if you need help, you can just call an attorney and ask, hey, this is my situation. What do I need to do? What do you think the evidence, what kind of evidence I can present? Because as I said, each case is different. If it's a parent-child abuse, what a child can present. By the way, VAwa is one of the best statutes for children, because what happens with children in VAwa is that VAwa allows a child to file, if it's a child of a permanent resident or a U.S. citizen, VAwa allows a child to self-petition until a child turns 25 years old. It's very important. It's better if the child files under before he or she turns 21, but the law allows you in certain situations to file even when you're under 25. The child will have to also demonstrate abuse and extreme cruelty. A stepchild can file as well, but in this situation, he or she will have to demonstrate that the parent-child relationship existed between the abuser and the stepchild. Usually it's demonstrated by showing that the marriage between the parents was what took place under the child before the child's 18th birthday. It's very important, though, to know that when a child uses VAwa, the standard is a little bit different than when a spouse uses VAwa. The child does not have to show that the marriage exists at the time of his or her filing, and the child does not have to show that the marriage was a real marriage. It's very important. So the evidence, as I said, would differ in each case. The person has to present as many evidence as he or she can with the filing. What happens first is before the petition is decided, the USCIS will issue something that's called, let's say, interim decision, decision before the real decision, which will allow the applicant to file for employment authorization. Also, there are different technicalities. If it is a battered spouse of a U.S. citizen, together with a petition, one can file for adjustment of status at the same time and file for employment authorization at the same time. It's very important to know this because it will help to get free from the abuser. That employment authorization and right to legally work will help the person to get free from the abuser and leave the abuser because it will provide financial independence. Many of the people who come to me, they say, well, my previous lawyer filed I-360 for me, and I still cannot get my employment authorization. So I ask them, was the I-485 filed? And they say, oh, no, it wasn't filed. You have the right as a spouse of a U.S. citizen to file I-485 together with I-360 and simultaneously ask for employment authorization. So in many instances, it is a mistake not to do it at the same time. Sometimes, of course, if you are married with a lawful permanent resident, then you will not be able to file I-360 and I-485 application for adjustment of status. It is because there is a line to wait for the petition to become current. Let's say if you were filing in a regular course of the events, first I-130 would be approved, and only after the priority date for I-130 becomes current, then you can apply for get the employment authorization together with I-485 if you're in the United States. So there are different legal technical issues of how documents should be submitted and when they should be submitted and what rights a person who is battered or subjected to extreme cruelty may have. One of the evidence, by the way, of the extreme cruelty can be a psychological report from a doctor showing that the person did suffer an abuse and the person maybe is undergoing treatment. It can be that the person was diagnosed with depression and anxiety, but doesn't have to be. But the fact that the doctor evaluated the person and said that she had sufficient time to spend with the person and believes that the person did suffer an abuse, usually is a very strong evidence for USCIS to prove, especially if the abuse is not physical, if the abuse is psychological. Because it's very important to remember that abuse does not have to be physical. Psychological abuse, what can it be? Well, it's name calling, very often name calling, threats. It's forcing the other person to do or tolerate something that the person does not want to be engaged in. Maybe it's illegal drug abuse. Maybe it's subjecting person to or watching pornography or participating in illegal acts. It doesn't have to be illegal acts. It can be anything that is forced upon the person. And in a regular situation, a person would be able to say, no, I don't want to be a part of it. But because he or she is dependent on the abuser, they cannot break free of this and get out of the situation. Very often in cases of VAwa, the USCIS, after the initial filing, is asking to present more evidence. It's not necessarily a bad thing. You don't have to be afraid that, well, they asked me to present more evidence, my case probably is weak. Maybe you could have done a better job at the beginning, but look at the request for more evidence as a second chance to prove your case. In almost all of my cases, when we receive an RFE, request for more evidence, we are able to provide a compelling case and case gets approved in the end. So it's not necessarily denial. You don't have to see it as a negative. It's a positive. It's a second chance for you to prove your case. Once I-360 is approved, what happens next? Well, if a person was married to a U.S. citizen, and here is an important thing, sometimes the U.S. citizen stops being a citizen or permanent resident after the case is filed. And it is so because in certain cases, even if it was a U.S. citizen who was the abuser, but was a naturalized U.S. citizen, and he or she lost his status, let's say a person was convicted of domestic violence or very serious offense, the service or USCIS initiated the removal proceedings and proceedings to take back the naturalization citizenship status. So technically, the VAwa applicant is no longer married to a person who is a U.S. citizen. What happens? Well, nothing is going to affect the VAwa application if the loss of the citizenship was connected to the abuse. So again, the VAwa applicant is protected here. So basically, after 1-360 is approved, if you haven't filed for adjustment of status, you should do it right away. If you have, then adjustment of status will be next to be considered, and in most of the cases, adjustment of status will be granted. When it will not be granted? Well, if there are criminal convictions, because one of the showings that the applicant has to show or has to demonstrate is that he or she is a person of good moral character. And basically, if there is a criminal past for the VAwa, in the VAwa applicant's history, I-360 probably will not be approved because the person will not be able to show good moral character. But it's not always so. Sometimes there are other issues for the adjustment of status that are on the way, even though the I-360 is approved. Once a self-petition is approved, the person can, if haven't done so, can apply for employment authorization. And there are different categories. The employment authorization can be granted to the applicant. It's recommended to read the instruction to I-765 form, application for employment authorization, before filing for it, because one can file for employment authorization, as I said, under different categories in the case of a battered spouse. And those categories sometimes they make a big difference because one can file as an applicant for adjustment, and employment authorization will be connected to a pending I-45 form. If I-45 form is not filed, then there are other categories one can file. There are two other options one can use. So it's better to consult with an attorney before filing your documents because there are little differences that may affect the case in the future. Adjustment of status of green card, of course, is the goal for the VAwa self-petitioner. And as I said, there are situations when even though I-360 is granted, the person still will not be able to easily get his or her green card. The situations may vary and depend on how the person entered the country, what visa was used, what other possible issues may arise. So often, even if the person cannot get adjustment with USCIS, the person may file for something called cancellation of removal for VAwa applicants. Cancellation of removal is something that a judge can grant to the person who is placed in the removal proceedings. So VAwa protections are available not only to those who are filing the case outside of the court, but they're also available to those who are already in immigration court proceedings. And if the person can demonstrate that he or she was abused, the person can get a green card through the court under VAwa cancellation of removal. What's good about VAwa cancellation of removal is that in most cases of cancellation, under regular cancellation, a person has to show that they have been in the country for a number of years and that their removal from the country will cause extreme hardship to a U.S. citizen or permanent resident, spouse, or parent, or somebody other than the applicant. For VAwa cancellation of removal, you do not have to show that if you are, as an abused person, will be removed from the country, that removal will cause extreme hardship to somebody else, except for you. So it's an easier showing. It's easier to have that cancellation granted as long as the abuse can be approved, as the judge will agree that the abuse took place. Another important aspect for VAwa cases is that it's not, you see, somebody will be filing for I-130 only if the initial filing, so I-130 was never filed for them after the marriage. But what if it was? What if the abuser first filed I-130 petition and the abused spouse received a conditional green card? And now is the time when the abuser decided to change his mind and decided, you know what, I'm not going to file a joint petition for you to get your permanent green card. Can the abused spouse proceed without the abuser? Yes, the abused spouse can proceed without the abuser. Actually, the abused spouse can proceed under two different categories. We're talking right now about I-751 form, and that form says that if your spouse does not want to file together with you for cancellation of removal, or for, removal of the conditional residency, you can nevertheless do it by yourself if you submit evidence of abuse and ask for a waiver of the joint filing. And if that waiver will be granted, if that petition will be granted, the abused spouse will still remain his or her rights to apply for citizenship based on 3 years rule, not 5 years. It's very important to know this because many people do not know this. If the I-751 was granted because they received a waiver and were found to be victims of abuse, they do not have to wait for 5 years to file for their citizenship. They can file for citizenship as if they were married to a U.S. citizen spouse. Another situation, let's say an abuser does not want to file for conditional residency and you file for divorce. Once the divorce is finalized and you are divorced from the person, you can nevertheless remove the condition from your green card by yourself if you can show that the marriage to the U.S. citizen was real. In this situation, however, you will have to wait for 5 years to file for the citizenship. But it might be easier sometimes to go to take this path rather than showing that you were abused. If, let's say, a person was very afraid during the marriage and they did not call the police, they did not use a shelter, so they don't have much evidence of the abuse, then they might just file for divorce, get the divorce, and then apply for removal of the condition on the green card by themselves. So there are different aspects of VAwa laws that can be very helpful. What's important to remember that there is hope and there is a way out of the abusive relationship. And it's very important, unfortunately, it's very important that the people have to be legally married. Even if the marriage later will be found invalid for the legal purposes, if the abuser was married twice and could not enter into legal marriage, nevertheless, the marriage has to be a legal marriage. Simply residing with a U.S. citizen or permanent resident spouse will not give the benefits of the VAwa to the spouse. The child and the parent, it's different stories. They don't have to have this relationship requirement, marriage requirement most of the times, but the spouse have to be the somebody who's applying, saying that their abused spouse, they have to be legally married. As always, you can ask questions about the situations and about different aspects of VAwa protection through my website. It's www.shautsova.com, shautsova.com. I will be happy to answer the questions. I believe this is it for today. Thank you for joining me. And as I said, I welcome questions. Every consultation, when you come to my office or you call my office, is confidential. It's very important to know in these cases. And in general, by the way, the VAwa submissions are confidential. They cannot be disclosed. The abuser will not know that you filed for yourself. Thank you very much and have a good evening.